All right, well, court will be in session. We'll call the first matter. This is Baxter County case 2018-369, State of Arkansas versus Lane Eggers. This matter appears to be for arraignment on charges of driving while intoxicated, a fourth offense, driving on a suspended license, failure to transfer vehicle registration, careless and prohibited driving, leaving the scene of an accident with property damage, and no liability insurance. Mr. Eggers, have you made any arrangements to be represented by an attorney?
Yes, sir, I have.
Okay. Who is your attorney?
Andrew Bailey.
Okay. And you're employing him privately or through the public defender's office?
Privately.
Okay. On the charges against you that I just read off, how do you now plead?
Not guilty, Your Honor.
Noting the plea of not guilty on the record, this is a matter set on the Division 3 docket of Judge Putman. The court will set your next appearance for September 6th.
6th.
That'll be in front of Judge Putman.
Putman, thank you, sir.
All right, you may be excused.
Your Honor, Mr. Bailey says he's not been employed by Mr. Eggers.
Is Mr. Eggers still there?
Yes, sir.
Mr. Eggers, you need to make arrangements with Mr. Bailey that are a little better. Our office, the prosecutor's office, has contacted Mr. Bailey's office and been informed that you haven't formalized your arrangement with him. So the court at this point, your plea stands at this point of not guilty. Court would advise you that you have a constitutional right to be represented by an attorney, and the way you exercise that right is you do what you apparently believe that you had done, which is hire the attorney of your choice, and the court does not get involved in that process. But I want to advise you that if in fact you discover through the hiring process that you are unable to afford to hire an attorney for any reason, then the court wants to make sure you understand you have an absolute right to an attorney, and in the circumstance you discover you can't afford to hire an attorney, that's where the court does become involved in appointing counsel for you. To secure appointed counsel, you would need to file a file a petition for the services of the Public Defender's Office. Those petitions are available there at the jail, and you can get one, fill it out, and turn it in if you get to that point. But I just wanted to make sure you understood how you get counsel if, in fact, your efforts to hire counsel does not reach fruition. I am advising you at this point that I'm noting on the record that you're attempting to hire Mr. Bailey. If you don't get an attorney in place, you aren't able to get an attorney in place, you should take whatever steps are necessary to have one by September 6th when you appear before Judge Putman. You may be excused now.
Thank you.
You bet. Court calls 2018-375, State of Arkansas versus Ryan Kinsley. Mr. Kinsley, you're appearing for purposes of arraignment here today on a charge of furnishing of prohibited articles, a Class C felony. Have you made any arrangements to be represented by an attorney?
Absolutely not.
Okay. Well, you in the past, well, maybe I probably shouldn't. I'll be wrong, but anyway, I believe you've used the Public Defender's Office in the past, have you not?
Multiple times, yes, sir.
That's what I thought. You know how to get a public defender. You'll need to fill out the application and fill it in if you want representation from the Public Defender's Office.
Yes, sir.
In the meantime, on the charge of furnishing prohibited articles, Class C felony, how do you now plead?
Not guilty.
All right. I'm noting your plea of not guilty. You're on the Division III docket of Judge Putman. I'm setting this down for a reappearance on September 6th. You may be excused.
Thank you.
Two 2018-366, State of Arkansas versus Kevin Wilson. Mr. Wilson, you're appearing before the court this morning for arraignment on charges. Have you made any arrangements to be represented by an attorney?
No, sir.
Well, I guess what I want to inquire is, what is your intention? Are you planning to hire counsel? Are you going to be applying to the public defender's office, or do you know?
I'm just going to plead guilty today, sir.
Well, I'm going to advise you that if you plead guilty and I accept that plea, I can go ahead and sentence you on the charges here today. It would appear to me that it's not in your best interest to do that, and I'm not going to accept a plea without you first speaking to an attorney. You have available to you the public defender's office. The way the right to an attorney works is that you're the way it works is that you have a constitutional right to be represented by an attorney, and I don't generally accept plea statements until you are represented by an attorney. What that constitutional right means is that you have the right to go out and hire whatever attorney you want to hire, and the court doesn't get involved in that process because that's a matter of private contract between you and the attorney you choose to hire. However, if the reason you aren't hiring an attorney is because you cannot afford an attorney, that's where the court gets involved. The court will appoint you counsel if you cannot afford counsel. The way you secure an appointed counsel is you make application to the public defender's office. The applications for the public defender's office are there at the jail, and if you'll ask the jailer can provide you a copy of that application. I strongly, given the nature of the charges in this matter, I strongly urge you to consider making arrangements to have an attorney, either by hiring one or filling out the application. At this time, on the charges of theft of property, a Class A misdemeanor, 4 counts, and criminal trespass, a Class B misdemeanor, 4 counts. The court is entering a plea of not guilty on your behalf and advising you to consult with an attorney. We'll bring you back in front of the court if you want to change that plea as soon as you have an attorney in place. The court is setting this matter by scheduling order. Your next scheduled appearance in court will be November 15th with a February 21st pretrial of 2019 pretrial date, March 21st plea deadline date, and your cases are set for trial the week of March 25th. I'm going to put this matter down for you to reappear in front of me on September 13th. That's a special appearance set to review the status of your attorney status on September 13th. Do you have any questions at this time?
No, sir.
All right, you may be excused. 2018-368, State of Arkansas versus Jamie Krug. Ms. Krug, you're appearing for arraignment on charges of making or uttering hot checks. This is charged as a Class D felony. Have you made any arrangements to be represented by an attorney?
Sir, right now I'm representing myself pro se, and I'm requesting time to obtain counsel.
Okay.
And I was wondering if I can have up to 30 to 60 days to do that.
Well, all right. The court just wants to make sure your intention is to hire counsel?
Yes, sir.
All right.
And I have entering plea of not guilty.
On the charges in this matter, I'm noting a plea of not guilty entered on your behalf. This case has been set. We're entering a scheduling order, as we do with every case when it first comes before us. And in your next appearance in court is November 15th. The rest of the scheduling order will set the matter for February 21st for a pretrial of 2019 for a pretrial, March 21st for a plea deadline, and it'll set during trial during the week of March 25th, 2019. All of those are in a scheduling order.
Okay.
In order to effectively represent yourself, you know, you would do well to get to come to understand how to get into the court filing system. We now have an e-filing system, and it's you'll need to gain access to the system through something called Public Court Connect.
Okay.
You can look up what's in the file on Public Court Connect, and you should be able to, among other things, there should be that scheduling order will be there setting those dates and everything.
Okay.
What I would advise you to do as quickly as possible to make arrangements for counsel.
Yes, I am. It's just I gotta have time to do that.
You do have time to do that.
Okay.
I do expect you to show up on. I'm ordering you to reappear on November 15th with counsel. That
Okay.
should give you sufficient.
And then
time.
at what time, sir?
At 9 o'clock.
At 9 o'clock. Okay.
All right.
Okay.
You may be excused.
Okay. Thank you so much.
Court calls 2018-192, State of Arkansas versus Sherry Dickerson. Ms. Dickerson, you're appearing at this time for a change of plea, is that correct?
Yes, sir.
And this change of plea is brought about by an agreement that's been reached with the prosecutor and negotiated on your behalf by Mr. Cooper. Is that?
Yes, sir.
Okay. So you've gone over the terms of the agreement and the punishment you're to receive with Mr. Cooper?
Yes, sir.
And do you feel you understand what the agreement is?
Yes, sir.
Are you satisfied with the advice and the representation that Mr. Cooper's provided you?
Yes, sir.
On the charges in this case of possession of a controlled substance, a Class D felony, and possession of drug paraphernalia for the use of methamphetamine, a separate Class D felony, how do you now plead?
Guilty.
You're in this plea of guilty pursuant to the agreement we were discussing. That agreement is set out in writing in the document I'm holding up called a plea statement. Have you read through and signed this plea statement?
Yeah.
You have?
Yes.
And in reading it over, do you feel you understood what's set out in it?
Yes, sir.
You then understand the nature of the charges against you and the full range of penalties you're facing?
Yes, sir.
You understand that by pleading guilty, you're giving up certain constitutional rights that you have?
Yes, sir.
The rights that you're giving up are the right to a trial by jury, the right to be represented by an attorney and assisted by an attorney throughout the trial process. You're giving up the right to confront witnesses that would appear and testify against you at trial, and you're giving up the right to appeal. All of those are rights you're giving up by pleading guilty. Do you understand that?
Yes, sir.
And understanding what you're giving up by pleading guilty, are you still willing to enter this plea?
Yes, sir.
Are you pleading guilty here today freely and voluntarily?
Yes.
Has anybody in any form or fashion forced you into this plea?
No.
As you enter this plea of guilty, are you admitting to the actions that led to your being charged with these crimes?
Yes, sir.
Are you admitting that on or about April 28th of 2018 here in Mountain Home, you were involved in a traffic stop in Mountain Home, and at the time you were found to be in possession of what's termed in the information a small amount of methamphetamine and a smoking device related to the use of methamphetamine?
Yes.
Based on those statements, the court's going to find that the defendant has freely and voluntarily entered her plea of guilty. She's done so after consulting an attorney and admitted to her actions that give the basis for the charges against her. On that basis, the court is going to formally accept her plea of guilty. However, pursuant to the terms of Act 346 of 1975 as amended and the terms of this agreement, the court is going to withhold formal adjudication of guilt and place Ms. Dickerson on 3 years of supervised probation subject to the standard terms and conditions of probation of this court. That's on each of those 2 Class D felonies, with those sentences to run concurrent with each other. The court is entering an order for her to pay court costs in the $200, a fine of $2,000, the statutory DNA fine of $250, a booking administration fee of $20, a public defender fee of $200, and a drug crime assessment of $125. All of those amounts will be due and payable as a term and condition of her probation. Payments are to be made in equal monthly installments, with the first payment to be due within the next 30 days, and then continuing each month thereafter until the whole amount is paid in full. Each payment must be of at least $100 and continue being made until all the amounts are paid in full. Attached to the terms and conditions, attached to the plea statement are the written terms and conditions of her probation. Court has reviewed them, and at this time is signing them, making those terms and conditions of probation an order of this court that the defendant is to comply with. The defendant herself has signed them, indicating that she has read, understands, and will comply with the terms and conditions of her probation. Ms. Dickerson, it's particularly important that you go over those written terms and conditions of probation. You're being given an opportunity to walk away from this without a felony conviction. So, and the key there is that you fully comply with all the terms, written terms and conditions of your probation. To that end, I'm going to direct you meet with Mr. Gilbert here, the probation officer, to go over those and be prepared for probation. Good luck, Chair. You may be excused. (2018) 360 State of Arkansas versus Darcy Dan James. All right. Ms. James, you're appearing here today on charges of to change your plea on the charges against you. Is that correct?
Yes, sir.
And this change of plea is brought about by an agreement that's been worked out for you by Mr. Cooper. Is that correct?
Yes, sir.
Have you discussed the terms of the agreement and the punishment you're to receive with Mr. Cooper?
Yes, sir.
And do you feel you understand what the deal or what the agreement
Yes,
is?
sir.
Are you satisfied with the advice and the representation you've had from Mr. Cooper?
Yes, sir.
On the charges in this case of possession of controlled substance Schedule 1 or 2, not methamphetamine, which is a Class D felony, possession of a controlled substance, marijuana, Class A misdemeanor, and possession of drug paraphernalia, a Class A misdemeanor. On those charges, how do you now plead?
Guilty.
You're entering this plea of guilty pursuant to the agreement in this case, is that correct?
Yes, sir.
And that agreement is in writing in the document called a plea statement that I'm now holding up. Have you read through and signed this plea statement?
Yes, sir.
And do you feel in reading over it, that you understand what's set out in the plea statement?
Yes, sir.
You then, therefore, understand the nature of the charges against you and the full range of penalties you're facing?
Yes, sir.
You understand the rights that you give up or surrender by pleading guilty?
Yes, sir.
The most important right you give up is your right to the jury trial, but with it you're also giving up the right to be represented by an attorney throughout the trial process. You're giving up the right to confront witnesses that would appear against you at trial, and you're giving up the right to appeal after trial.
Yes, sir.
You understand these rights that you're giving up?
Yes, sir.
And understanding what rights you're giving up, are you still willing to plead guilty?
Yes, sir.
Are you pleading guilty here today freely and voluntarily?
Yes, sir.
Has anybody in any form or fashion forced you into this plea?
No, sir.
As you enter this plea, are you admitting to your actions that were the basis of this these charges?
Yes, sir.
Are you admitting that on or about August 15th, 2018, here in Baxter County Officer, you were asleep in the car in a vehicle with marijuana and a device for smoking marijuana
Yes,
in the
sir.
car, and also that you had pills, methadone hydrochloride pills in your possession?
Yes, sir.
Based on those statements, the court's going to find that the defendant has freely and voluntarily entered a plea of guilty, done so after consulting an attorney, and is admitted to actions that constitute the basis of the charges against her here in this case. On that basis, the court will formally accept her plea of guilty, but pursuant to Act 346 of 1975 as it's currently amended, and to the terms of this agreement, the court's going to withhold formal finding of guilt on the defendant and place the defendant on supervised probation for a period of 4 years on the felony allegation and 12 months on each of the misdemeanor allegations in this case. That probation will be subject to the standard terms and conditions of probation of this court, and all those sentences will run concurrent with each other. The court will impose court costs of $200, a fine of $2,000, the statutory DNA fine of $250, book administration fee of $20, public defender's fees of $200, and drug court assessment of drug crime assessment of $125. All of those amounts will be due and payable as a term and condition of her probation, with payments to be made in regular monthly installments of not less than $100 per month. Those installment payments will start to be due within 30 days of this date and continue each month thereafter until the full amount is paid. That will be the order of the court. The court has reviewed the written terms and conditions of probation and is currently signing those written terms and conditions of probation, making them an order of this court that the defendant is required to comply with. The defendant herself has signed them, indicating that she has read, understands, and will comply with these terms and conditions of probation. That will be the order of this court. I'm going to direct, just to emphasize for you the importance of making sure you read over those written terms and conditions of probation, and make sure you stay in compliance with them, because as I said to another individual earlier, you'll be given an opportunity to walk away without a felony conviction or any type of conviction, as long as you fully comply with those terms and conditions of probation.
Yes, sir.
That'll be the order of the court. I'm going to direct you meet with the probation officer at this time. You may be excused.